And I would like to move over to Rogier Raas. Rogier is also an academic. He's a professor in Leiden University, a law professor, and he's partner at Stibbe. So I guess you're also one of the crowdfunding experts in the top tier law firms nowadays. So I will give the floor to you, and I will launch your presentation.
Thank you, Jasper. Thank you for this introduction. I'm going to talk to you a few minutes about financial services regulation and all the other legal aspects you may encounter when you would like to start either a crowdfunding platform or become involved in crowdfunding. It's actually quite easy. Everything you would like to know is in this book. It's not that thick. Well, it will take you 2-3 nights to read through it, and then you can do it on your own. And what I would like to do in these 10 minutes is maybe organize those letters a bit for you, to give you a little bit of background and idea of the items you should be focusing on when looking at these kinds of initiatives. And I think Christophe already gave an excellent summary of what you should be looking at in this space, especially with respect to financial services regulation. If you look at well, for instance, the Dutch rules, but also in a more international context, the European harmonized rules, these are really the prohibitions you should be concerned about. I've listed 4 of them. It may be interesting for you to know that I actually asked someone to count the number of prohibitions that are in this book. They're not 4, they're 183. So there are 183 prohibitions in this book, this law manual, things that you're not allowed to do. So that means that you're operating in an environment whereby regulators say and legislators say these are things that you cannot do. And I think that is at the heart of the problem of trying to combine financial services regulation with the existing laws, and that is that the lawmakers and the regulators focus on prohibitions. So it means something is prohibited unless it is expressly allowed by the legislator, and that is at the heart of many of the discussions you can encounter when you would launch an initiative like this, because these rules are focused on things that we know. We know banks, we know insurance companies, we know loan providers, we know investment firms, but we don't know, at least from a legal perspective, we don't know crowdfunders yet, we don't know crowdfunding initiatives yet, we don't know the platforms yet. So the natural inclination of policymakers and regulators is to try to look for elements in the initiative that they know. So they'll say, you actually look like a bank, or basically what you're doing is extending a loan. That's allowed unless we specifically allow you to. So that's many of the discussions that you can face. If you're interested, later on today we can focus on those prohibitions a bit more. But I'd like to move to the next subject, and that is if you run into one of those prohibitions, for instance, the prohibition to obtain repayable funds as a deposit, as a platform, and you would like to have a solution for that. How do you go about trying to create an exemption, or to make sure that you do not fall under that prohibition? You can, of course, start reading this book again, but then you will see that the actual provisions therein are rather general, rather vague. They're not very specific in what they would like to protect or prohibit. So that means that at some point you may want to discuss this, next item on the list, may want to discuss this with a person that can help you with that. And then the natural thing to do may be to go to a regulator, because that's the beauty of financial services regulation. There is actually there is a party, there is an agency you can talk to, you can visit, and see what they have to say about that. I think in general, I'm all in favor of an open dialogue with regulators. There's nothing wrong with that. And, especially speaking for the Dutch situation, I think that our regulators have come a long way in opening and being open to discussions with parties, whether they are big or small, to basically help them setting the first steps. But there's also a risk involved, and that risk is that you should be aware of the fact what the actual end result of that discussion may or could be. Regulators in general are not allowed or are not capable, rather, as opposed to, for instance, some of the tax services do in many countries, including the Netherlands. They're not always allowed to give formal opinions or formal sign-off on a project. That's one. So the best result you will probably achieve is that they will say something like, "We have no further questions," or we have looked at your initiative. You are operating this initiative at your own risk, but we have looked at it and we can imagine that the conclusions that you've arrived at yourself can be ours as well. So you will probably get a very generic and rather vague sign-off from a regulator, which is not necessarily a bad thing, but it's something to keep in mind, just to keep your expectations a bit realistic. The second point is that there's also a risk if you get an answer that you were not looking for. It could very well be that after you have read that book, you arrive at your own conclusion based on all those very general norms that are in there, that your initiative actually falls outside all of these prohibitions, which of course is a good thing. Then, if you want to test that against a regulator and say, do you agree with my analysis? And they would say no, for some reason. Perhaps because, well, they didn't read that book as well as you did, or they simply have a different view. And if they would be plainly wrong, they would be clearly wrong in their approach, then what do? If you then start with your initiative knowing that the regulator doesn't agree with you, you may have a problem when they actually start to enforce, because then you know you're no longer in good faith, you know what the regulator's opinion is, and yet you decide to continue. And if you are then in that enforcement process, if you are before a judge, then that judge will probably say, why did you go ahead knowing that this was not allowed? Whereas if you arrive at your own conclusions, and those conclusions are fair, and those conclusions are of course based on those same general and open provisions, but your conclusion is sound and it is defendable, then you have a very different discussion in an enforcement stage. And it may even never come to an enforcement stage, because the regulator will then say, okay, we can see the reasoning that you applied. We don't agree with that. We will give you 6 months to get your act together, and then you have to be compliant, and that's the end of the story. Also, if you get an informal opinion of a regulator that you do not agree with, there is no, at least in the Netherlands, there is no formal protection. You cannot go to the court to challenge that opinion. There's basically nothing you can do. The only thing you can do is quite burdensome, but the thing what you can do is apply for the license that you don't need. Then you get that license, and then you object against the license that you got, and then you say to the regulator, I shouldn't have received this license because I should be exempt. And that decision you can test before a court. That's of course a very burdensome process. So my message would be, yes, go and talk to a regulator, but do it wisely and think ahead of what the questions are that you would like to ask to that regulator. So that's the regulatory side of things. That's only part of what you should be focusing on. There are a lot of consumer protection laws that you should be worrying about, and those consumer protection laws are actually also harmonized at an EU level, and they are regulated by the Dutch Authority for the Financial Markets. So also there they can enforce if you do not comply with those consumer protection laws. And in particular, the Unfair Commercial Practices Directive, which applies in all 27 member states, is particularly important because that directive defines what unfair commercial practices are. Well, first of all, there are aggressive practices that you should not employ. Well, when looking at this room, I don't see you as the particularly aggressive type. Just for your information, you cannot threaten to exercise physical violence. The directive doesn't say whether you can actually employ physical violence, but you can't threaten it. Threaten that violence. So that's the aggressive side. That's normally fine. But the misleading aspect is a very important part. Your website, your documentation, your general conditions, and everything should be consistent. The message should be consistent with what you're actually offering. If you're leaving things out, if you don't describe the risks accurately, then you could face a charge under the Unfair Commercial Practices Directive. And a regulator could say, this is misleading, this is incomplete, and also an individual, an investor, or a third party could say, this is an unfair practice, I have damage, and I'm going to claim that damage with you. And just to be sure, and then I'll finish off, this Unfair Commercial Practices Directive applies to the unregulated and to the regulated space. So even though you are not a licensed bank or investment fund or whatever, as soon as you deal with retail investors, these are the rules to look at. Well, that's a very short introduction, but I'm sure we'll be able to talk a bit more later on.
Thank you, Rogier. So what